5 seconds to go. Start. But it is equally well settled that the act said to have been committed by a public officer must have reasonable connection with the duty sought to be discharged by such public officer. If the act complained of has no nexus, reasonable connection, or relevance to the official act or duty of such public servant and is otherwise illegal, unlawful, or in the nature of an offence, he cannot get shelter under section 197 of the code. In other words, protection afforded by the said section is qualified and conditional. Mr. Tulsi no doubt submitted that the appellant was a police officer. He was on duty. He had received a message about rioting and law and order situation at Baliaghatha. He therefore had gone to the spot pursuant to the said message in police uniform in police jeep to deal with the situation. All the ingredients of section 197 of the code were thus satisfied, and the High Court was wrong in not applying the said provision. I am unable to agree with Mr. Tulsi. In my judgment, it is precisely in such cases that the court is called upon to consider whether the public servant was acting or purporting to act in discharge of his duty, or it was merely a cloak for doing illegal act under the excuse of his status as a public servant, and by taking undue advantage of his position he was committing an offense or an unlawful act. In such situations, when the question comes up for consideration before a court of law as to the applicability or otherwise of section 197 of the code, it is not only the power but the duty of the court to apply its mind to the fact situation before it. It should ensure that, on the one hand, the public servant is protected if the case is covered by section 197 of the code, and on the other hand, appropriate action would be allowed to be taken if the provision is not attracted and under the guise of his position as public servant he is trying to take undue advantage. In Chaudhary Parveen Sharma versus State of West Bengal and another, reported in 2009 3 SCC 398, the appellant's husband had suffered grievous injury in a shootout for which a case was registered and police investigation was undertaken. The appellant had filed a complaint before the magistrate that the respondent number 2 investigating officer and the co-accused visited her house under the pretext of conducting an investigation, threatened her and her husband to make a tutored statement, and had also tried to obtain the husband's signature on a blank paper under threatening circumstances. While the magistrate had taken cognizance, the High Court had quashed the proceedings for want of sanction. In such circumstances, the following observations were made. The direction which had been given by this court as far back as in 1971 in Bhagwan Prasad Srivastava case 1972 SCC 56, it holds good even today. All acts done by a public servant in the purported discharge of his official duties cannot, as a matter of course, be brought under the protective umbrella of section 197 CRPC. On the other hand, there can be cases of misuse and or abuse of powers vested in a public servant which can never be said to be a part of the official duties required to be performed by him. As mentioned in Bhagavan Prasad Srivastava case, the underlying object of Section 197 CRPC is to enable the authorities to scrutinize the allegations made against a public servant to shield him/her against frivolous, vexatious, or false prosecution initiated with the main object of causing embarrassment and harassment to the said official. However, as indicated herein above, if the authority vested in a public servant is misused for doing things which are not otherwise permitted under the law, such acts cannot claim the protection of Section 197 CRPC and have to be considered dehors the duties which a public servant is required to discharge or perform. Hence, in respect of prosecution for such excesses or misuse of authority, no protection can be demanded by the public servant concerned. In the instant case, certain deeds and acts have been attributed to respondent 2 and another accused, which cannot be said to have been part of the official duties to be performed by respondent 2. Hence, in our view, respondent 2 was not entitled to the protection of Section 197 CRPC in respect of such acts. The court, while stating that the respondent number 2 was not entitled to the protection under Section 197 CRPC, was of the view that if the authority which has been vested in a public servant is misused or abused for committing acts which are not otherwise permitted under the law, one cannot claim recourse under Section 197 CRPC. In such circumstances, the acts committed must be considered dehors the duties which a public servant is required to discharge or perform. In Urmila Devi versus Yudhvir Singh, reported in 2013-15 SCC 624, a complaint was filed by M alleging that the appellant and R were living in an illicit relationship. Therefore, the respondent subdivisional magistrate directed the Tahsildar to inquire into the matter and also directed the DSP concerned to conduct a special investigation. It was alleged that the respondent had forcibly entered the house of the appellant at 10 p.m. with his investigation team equipped with video cameras to carry out a search of the appellant's house. It was further alleged that R was forced to remove his clothes in front of the other officials and that both the appellant and R were taken to a civil hospital where they were forced to undergo a medical examination against their will. The medical examination of the appellant was also alleged to have been conducted by a male doctor. Furthermore, it was alleged that when the appellant and R filed a complaint against M, the respondent threatened them to withdraw the same. The court stated that none of the acts alleged against the respondent can, by any stretch of imagination, be held to have been carried out in his capacity as an executive magistrate. Hence, the invocation of Section 197 CRPC was wholly uncalled for, while emphasizing that the test of direct and reasonable connection between the official duty of the accused and the acts allegedly committed by him is the true test. The court stressed that public functionaries cannot, under the cloak of the purported discharge of official duties, resort to the harassment and humiliation of the citizens on the pretext of a complaint having been received by them. The relevant observations are reproduced herein below. The test of direct and reasonable connection between the official duty of the accused and the acts allegedly committed by them is therefore The true test to be applied while deciding whether the protection of Section 197 CRPC is available. Stop.